Good morning, everybody, and welcome to the first in a series of DMH employment webinars. So I'm delighted that so many of you could join us this morning, and we had a huge number of registrations and people now joining us on today's furlough operating issues and what next webinar. So I'm going to be talking this morning around some of the difficult or more difficult furlough operating issues, and I'm delighted to be joined by my colleagues Rustam Tata, head of the employment team at DMH this morning, and Abigail Mayno. And I'm sure many of you have dealt with Abigail and Rustam and myself over the last few months and weeks on furlough issues as well. So Rustam and I will start by talking through some of the trickier operating issues, and Abigail's going to look at some of the what we are calling phase 2 issues, which is around what you are going to need to be considering for when furlough ends on the 30th of June. So we're talking to a lot of clients at the moment who are asking the question, what is going to happen when furlough ends? Now, before we kick off properly, just a few housekeeping rules. We expect this morning's webinar to last around 50 minutes to an hour, depending on questions. With regard to questions, we hope to answer as many of your questions as possible. A number of you have pre-submitted questions, so that's great. We've got a good idea of what the main issues are, and thankfully they align with what we're going to be discussing. Please do use the Q&A button to submit any further questions you've got. And what we're going to do is, after about 20 minutes, we'll have a Q&A session, and we'll then move on to Abigail's session. And then at the end of that, we'll have a further Q&A. So lots of time for you to submit questions and hopefully for us to be able to answer as many of those as possible. Where we don't answer them, we'll come back to you individually, if that's okay. And we also will be sending out a link following the webinar, which will be a link to the slides on our website. So I will kick off with my session. So let's get started with some of the basics and help warnings. I think all employment lawyers have been using that word help warnings quite a lot with regards to furlough. So it seems a lifetime away, doesn't it, since furlough was introduced by reason of the coronavirus job retention scheme. I think most of us find it much easier to just call it the furlough scheme now. But when the Chancellor announced it on the 20th of March, it was a scheme that allowed a significant breathing space for employers who had already, a lot of employers had sent staff home on unpaid leave, were worrying about how they were going to pay them, and had seen significant drop-offs in work. So the scheme in itself was incredibly welcome. What happened, however, was that we didn't receive guidance as to how that scheme would operate until the following week on the 26th of March. And then subsequently, we've had multiple further updates, which have caused great consternation amongst HR and employment lawyers as to quite what those guidance documents should be interpreted as. I think we're on guidance number 7. And in addition to what was the original standard guidance, we've had lots more guides in terms of how to calculate wages in order to access the online portal. So lots of guidance now. And we've also had what is called the HM Treasury Direction that was issued on the 15th of April. Now that's important because the HM Treasury Direction is basically the instruction to HMRC as to how the scheme should be operated. And that direction document is as close to the law as we're going to get. And it's that document that will take precedence in respect of ambiguities and what we probably expect are going to be some considerable court cases in respect of the operating nature of the scheme, and employees also looking at how furlough has operated from employment law principles. So the health warning does come on the basis that there are still discrepancies between the guidance documents and the HM Treasury direction. So there is still significant scope for uncertainty, and you do need to bear that in mind. So looking at some of the principles, or looking at the main principle actually of the furlough scheme. So this has actually appeared in most of the guidance documents as we've gone on. But if you look on the slide here, the overarching spirit of the scheme is to help employers whose operations have been severely impacted to retain employees and protect the UK economy. Now, quite what severely impacted will be taken to mean, we don't know. There is no definition to help us with that. But what the spirit of the scheme does also go on to say is that all employers are eligible to claim under the scheme, because it's recognised that different businesses face different impacts from coronavirus. So those impacts may still impact severely upon organisations, upon employers who have large cash reserves, but, for example, have no work for employees at the moment. They are still impacted by coronavirus, and therefore they are still able to take advantage and access the scheme in order to claim wage costs. There's been quite a lot said about affordability and whether there was an affordability criteria that HMRC were going to apply. Now, that hasn't appeared in the scheme, but you've probably all seen media storms in respect of the potential corporate reputational issues for employers who possibly are cash rich and are being criticised for accessing the scheme. However, the affordability factor has not been set out in the guidance, and it's not been set out in the direction. However, I do just want to give another health warning in respect of one of the clauses in the direction, and I think you do need to bear this in mind as you are using the scheme. So I'll just read it out from the direction. So no claim may be made in respect of an employee if it is abusive or is otherwise contrary to the exceptional purpose of the scheme. So bear that in mind, perhaps, when you're considering perhaps using furlough for certain employees, perhaps, and I'll come on to that in a moment. During the course of our webinar, I should have said this at the start, sorry, but we are going to have a number of polls. We'd like to hear what you're doing and your experiences. So what I'm going to do is move to the first poll, which is to get an indication as to what percentage of your staff you furloughed within your organisation so far. Now, anyone on a smartphone, you will need to scroll to the bottom to see the submit button. So please make sure you do that. But we'll just give you time to work through what percentage of staff you furloughed. So at the moment, I'm just waiting for the results. And live TV, live webinars, we haven't got children and we haven't got animals. We might not have a poll result, but that doesn't matter, because if we haven't got one there, and I apologise because it doesn't look as though those results have come up. Oh, they have. That's my impatience. So hopefully you can see the results that have just been shared. So it looks as though most organisations are in that less than 20%, but quite a lot, yeah, over 50% have furloughed 21% or more. So a fifth of the workforce is still a significant number. We have seen lots of stats come out on the percentage of staff furloughed, and what I think is really interesting is the stat that over 70% of employers have actually utilised the furlough scheme in some way. So I suspect that the vast majority of you on the webinar today will have used the scheme, and therefore that's probably why we've got so many of you now who've joined us. So I want to now move to some of the issues that you might be facing because you've used the furlough scheme and are continuing to use it. And I'm going to look at 3 issues that I think are causing some problems at the moment. So the first is there a right to be furloughed? Now, I want to sort of debunk this myth straight away. There is no right to be furloughed. Many employees seem to think that there is, and are making demands, and sort of quite aggressive demands on employers, and seeking to sort of tune into morality reasons for furloughing staff. It is completely at the employer's discretion to decide whether they're going to use the scheme to claim wage costs. If they do not wish to use the scheme, there is no right for an employee to bring any sort of claim under the scheme against the employer because they haven't been furloughed. And remember, the job retention scheme is a scheme that is between HMRC and the employer. It's not a scheme that the employee themselves are party to. They will be a beneficiary, but it is a scheme that is between HMRC and the employer. Now, the situations that we are seeing where employees are asking, or in some cases demanding, to be furloughed are those situations where somebody might have resigned from your employment and they've found that the next employer has withdrawn the next job offer, and therefore they're left in a situation where they've got no job to go to and they're working through their notice with you. And that notice may well be ending today, 30th of April, maybe ending 31st of May. But because the job retention scheme is continuing until the 30th of June, they're wanting that notice perhaps to be extended. Or if the notice has already expired, asking to be rehired. Now, you can do both of those things if you want to, but what you need to consider, either with people who've given notice, people who are asking to be rehired, people who may say, I want to go on to furlough because I've got childcare responsibilities or caring responsibilities, and I can't work from home, then you need to consider the extra cost and the extra administrative burden and the extra employment liabilities that do tie in with somebody who is going to be placed on furlough, who might otherwise not have continued in your employment. So those additional financial costs, if you look at accrued annual leave, and then payment of annual leave, if annual leave is taken during the furlough period. For people on notice, there is the potential for the notice payment to be paid at a higher rate than the 80% that you will be able to claim from HMRC. For anyone with 2 years or more employment, you've got employment liabilities. What happens at the end of furlough? So you might otherwise have not had that issue had you not rehired somebody, or perhaps not extended somebody's notice period. So there are additional costs, additional liabilities, and additional admin issues that you certainly do need to consider when you're dealing with a request from somebody to be furloughed. Okay, moving on to the next issue that has created some concern as well is furlough and second employment. So when the scheme was originally announced, it wasn't considered that it was going to permit somebody to be furloughed from one organisation and take up second employment with a completely different employer. The guidance didn't specifically state you couldn't, but equally it didn't state you could. And there was something around perhaps say, sort of, is it right that somebody's getting 80% of pay from the government but is then able to take a full-time job or a part-time job elsewhere? Well, we have had the clarification that second employment is allowed. The scheme does not restrict an employee being furloughed and then taking a job elsewhere. However, you may already have in your own employment contracts clauses to say that employees need to seek your consent if they want to take second employment. And remember, your employment contract continues. All the employment liabilities and rights and obligations, they continue irrespective of the furlough scheme. So first of all, check your own employment contracts. Do they allow second employment? Do they allow second employment on the basis that you don't unreasonably refuse it? What considerations should you be taking into account in respect of a request by one of your employees to work elsewhere? Well, there might be considerations along the lines of, if you furloughed somebody, do you perhaps want to get them back into your workplace quickly? And is that going to be possible if they've taken second employment? If you're wanting to make use of furlough on, furlough off, then is that going to work if somebody's in a second job? Are you concerned about conflicts of interest? So obviously it's unlikely you're going to want your employee to go and work for a competitor. It may also be the case that you don't want your employee to go and work for an employer where there might be a corporate reputational impact on your organisation. So there's a number of issues that you need to take into account, and same rules for all. What level of consistency? Well, perhaps have a second employment on furlough policy, or at least some guidelines for employees, even guidelines for you as HR, so when you get the requests, you can apply a degree of consistency and ask similar questions in respect of these requests that are being made. It might actually save you some time on the consideration issue. Okay, so moving to my last question around furlough and some of the issues that are now coming out with, is my initial furlough agreement fit for purpose? So we've had the benefit of a number of guidance documents, and most of you will probably have kicked off your furloughing in the last week of March, with probably perhaps a 1st of April furlough start date for people. At that stage, we had limited guidance. You might now want to look at your furlough agreement and see, do you need to make changes? Do you want to make changes? And then how about, how do you go about making those changes? So your options on seeking changes are exactly the same as when you put your original proposed furlough to employees. You will need to seek employees' consent to any changes that you are seeking. And what if they won't sign? What if employees won't sign a new furlough agreement? Well, if they won't sign a new furlough agreement, then I'm afraid you are stuck with your original one, because you can't unilaterally force changes on employees. Again, same basic employment law principles continue to apply during furlough. So if you are looking at changing, what are some of the things that you might want to change in your furlough agreement? So just moving to the next slide, some of the things that are possibly there are top-ups. So you may be paying more than the amount you're going to get back from HMRC. If you are you able to continue to afford to pay more now the scheme's been extended to the 30th of June? Alternatively, you may only be paying the 80% that you're recovering from HMRC, and you might actually want to increase your top up now. You might want to look at the ability to furlough on and off that we now know you can do. So we've got a minimum 3-week furlough period, but you may want to do furlough on off to share the burden of work. You might want to look at the benefits and the pension contributions. Do you reduce those? Do you change those? So if you're paying more than the 3% minimum employer contribution, is that something now that you can still afford? Is that something that you would want to discuss with employees about reducing? Secondary employment, again, you might want to look at putting some wording into the furlough agreement about secondary employment so people are clear on what considerations there are with regards to that. And you might also want to reference training. So any training that you would like employees to do whilst they are furloughed. Again, you might want to set expectations that you may request they carry out some training. Taking annual leave, I'm not going to steal Rustam's thunder on this because this is the big one. You know, how do you deal with annual leave during furlough? And Rustam's going to talk about that. But before I move to Rustam, just one additional poll. Taking into account how you found furlough, how your furlough agreements are operating, and what I've just said, how many of you are likely to consider changes to your furlough agreements prior to the 30th of June? So 3 relatively simple questions here. Hopefully we won't get all of you in the unsure box. Okay, and hopefully we will get your results very shortly. Okay, so we've got 18% looking at changes that they will definitely make. We've got 34% of you unsure, and 48% of you probably traumatized and suffering from furloughitis, who are definitely going nowhere near their furlough agreements again. So I don't blame you actually, but for those that are over 50% that are looking at changes, then if you do need any help with those, then obviously please do let us know. And I'm going to pass over to Rustam now, and he's going to take you through 3 further issues that are potential furlough headaches. So Rustam, over to you.
Okay, well, thank you very much, Rebecca, and good morning, everybody. And yes, furloughitis, I think that's probably a new condition that's going to enter the HR medico lexicon. Now, first area I'm going to talk to is time off from furlough, or really annual leave during a period of furlough. And one of the questions that arose initially was whether or not it's possible to take a period of annual leave during furlough, whether annual leave would accrue during a period of furlough, and the rate of pay which would apply for that annual leave. We also then had further complications that have arisen since the introduction of amending regulations to the original working time regulations, and those amending regulations provide for carryover of up to 4 weeks annual leave to be taken over the next 2 holiday years of the employer. And then ultimately, as Rebecca was saying earlier on, I think we're on version 7 now of the guidance that's been issued by the government. And somewhat unhelpfully, it wasn't the guidance to employers that contained the clarification of holiday pay, but it was the guidance written for employees, which, as I say, gave some clarification, although a degree of uncertainty does still remain. So looking then at each of those issues, it's now relatively clear that holiday will accrue during a period of furlough. It is also clear that holiday can be taken during a period of furlough leave. And it's also now clarified that the rate of pay which has to be applied during a period of furlough is the full 100% pay. And for these purposes, I think 100% has to not only be 100% of base pay, but also has to include those elements, for instance, of commission or overtime, which under recent case law decisions and some legislative changes have said that they should be included when you are calculating effectively the week's pay for the purpose of calculating holiday pay. The amending regulations, I think the confusion or difficulty there arises because I think over the interpretation and the scope of the employees or the workers to which those regulations apply. I think my view, albeit it's probably a tougher view on employees, is to say that the regulations talk in terms of it not having been reasonably practicable for the employee to take a period of leave. Well, I think that if it's accepted that there is nothing inconsistent with being able to take a period of holiday whilst you're on furlough, that an employee is not going to be able to argue that it was not reasonably practicable for them to take a period of annual leave simply because they were on furlough. And I have to say that's consistent with the Minister when announcing the new regulations, said that essentially these regulations were to provide support for those employees who were essentially having to work in the national interest at a time of crisis. So clearly, key workers, NHS workers, certain workers in relation to supermarket chains and food supply chains could all fall in that definition. But I think a lot of other sectors wouldn't fall within that. So in my view, I think an employer can take a relatively robust view on that point. And then finally, the revised guidance, as I said, does now provide a high degree of clarification. What it doesn't completely answer, as is so often the case in relation to the furlough scheme, doesn't completely answer whether or not an employer can require the employee to take a period of holiday during furlough. Now, in my view, the pre-existing law already provides for that and already gives the employer the power to require an employee under the working time regulations to take a period of leave, provided the period of notice that the employer gives to the employee is at least twice as long as the period of holiday which the employee is to take. So if they are to take 1 week's leave, the employer must give them at least 2 weeks' notice. So moving on then from holiday and furlough, one of the things I think that we're all struggling with a little bit is managing contact during a period of furlough. Now, unlike with the maternity provisions, where of course over a number of years we've managed to develop a system of keeping in touch days, which I think generally employers and employees find as being a positive development, there is no equivalent of that under the furlough scheme. And as Rebecca said earlier on, the employment contract continues during a period of furlough, and so a number of practical issues arise. For instance, the need perhaps to communicate key business issues or developments to your staff, the need to involve furloughed employees in regular team meetings, and of course ensuring that development opportunities are highlighted and brought to the attention of those who are on furlough. The risk here, of course, is that employees on furlough are out of sight and are therefore essentially out of mind. And the risk must be, for instance, that an employee on furlough who isn't aware of an opportunity subsequently returns to work and is made redundant. And then the argument will be, well, had I been made aware of that other opportunity, I might have been able to pursue it, and I wouldn't then have been facing redundancy. And that almost certainly would give them a valuable unfair dismissal claim and possibly, depending on the circumstances, a discrimination claim. And then, as I've said there, managing the personal development and training of individuals, how to actually deal with that in the context of people who are on furlough. What about volunteering opportunities? I think there's a degree of overlap here with what Rebecca was referring to earlier on in the context of second employments. Again, I think there'll be considerations as to what particular volunteering opportunities you would want your staff to undertake, and you'd want some clarity around the level of commitment that they're giving and their ability, of course, to be able to return from furlough, possibly at relatively short notice, without their saying, oh no, I'm now committed because of this volunteering opportunity that you agreed I could do and I can't come back for another 6 weeks. And then I think you've got the very knotty issue about grievance and disciplinary processes. How do we manage those in respect of employees who are on furlough? So I think now I've got a poll for you here, and so the poll really looking and saying, how do you manage contact? How are we dealing with those areas? What are the steps that you're taking for your organisations? And then the poll question, which just may or may not come up, or we may need to move on. I don't mind, Amber, because it's going to get edited. So our next poll then really about collective consultation. I think it'd be very interesting to see how far you and your organisations are progressed in the context of collective consultation processes. So we'll have the poll question come up now, and hopefully that'll all be edited beautifully. And I'll then say, moving on then to the considering redundancies during furlough. I put there yes, probably, and I think that probably is right. And I'm aware that a number of employers with employees on furlough are moving forward potentially with redundancy processes. However, I think there are a number of practical logistical issues that do arise in the context of trying to implement collective redundancy processes. So as well as the issue of when you trigger collective consultation requirements, and as a headline, of course, the obligation to consult collectively where you're looking at potentially making redundant 20 or more employees at a single establishment within a period of 90 days. That's one issue. How will you carry out elections for the employee reps where you have people on furlough? So there are logistical issues. And then I think that feeds into probably the technical issue, which I have to say I'm personally kind of grappling with, and I know with my colleagues we have sort of differing views, whether or not an individual acting as an employee rep is actually carrying out work. So on one analysis, one might say, well, if they're not directly employed to be an employee rep, it's not part of their formal duties, it's a voluntary activity that the individual is undertaking, albeit in the context of their employment, and therefore they're carrying out the role of employee rep doesn't amount to work, and therefore it doesn't undermine the furlough status and, critically, of course, for most employers, the furlough claim to the government scheme. On the other hand, of course, being an employee rep is very much in the context of the individual's employment, is very much in the context of the employer's operation and organisation, and very much in the context of the employer's statutory obligations to follow a period and a process of collective consultation where they're looking at making mass redundancies. So that would perhaps appear to point much more towards saying that it really is very much part and parcel or bound up with the employment relationship. So I think there is quite a tricky balance there in terms of determining how to deal with individuals who carry out and are elected as employee reps if they are perhaps themselves furloughed. So, for example, do you have to take the view that you will take them off furlough and then, of course, potentially pay them at 100% of their normal pay simply so that they can carry out this role? And it might be sensible to consider that. And then finally, what will a fair selection process look like in the context of collective redundancies where we're still within a period of furlough? Well, while I think employment tribunals will adjust, they'll sort of reset the needle slightly when it comes to looking to what they expect an employer to have done and how they expect them to have gone about and assessed, for instance, performance and carried out a fair selection process. I don't think they will go so far as to say that it's acceptable for an employer, for instance, to say, well, we couldn't gather information because the manager that we would have spoken to ask for this information was off on furlough, and therefore we couldn't get accurate data or we couldn't get good data in terms of assessing or scoring individuals. I think that runs the very serious risk of undermining the fairness of the dismissal. And that's supposed to be a drum roll there in the corner, and then we move on to probably the two big questions now that people are thinking about, which is, can notice be served during a period of furlough? And also, can the notice payment and or the statutory redundancy pay elements be considered wage costs to be claimed under the government scheme? Well, I think at the moment, prevailing view is that notice can run during a period of furlough. There is probably an argument that notice can't expire until just after the end of the furlough period, but notice can probably run. And that, of course, it would be helpful for a number of employers if they're able then to use that and reclaim against the scheme. Now, there's 2 points there. The first is whether they will be able to claim against the scheme, or whether, for instance, in due course, HMRC will say, no, notice obligations, insofar as they didn't arise and didn't accrue during the period of furlough, were freestanding pre-existing obligations, and it's not right, therefore, it's not within the spirit of the scheme, as Rebecca was referring to earlier on, to seek to reclaim those and for those to be effectively paid through the scheme and subsidised by the state and ultimately, of course, by most of us as taxpayers. And so the notice element might potentially be disallowed in due course. But the further issue, of course, is what's the rate of notice pay that should be applied when an individual is on furlough. Now, there are some technical arguments that actually it probably is only the 80% or the furlough rate. But I have to say there are also some maybe not quite such strong technical arguments, but I think the general and prevailing view is that employment tribunals will try very hard to find a way to say that notice pay should be at 100%. And certainly from an overall fairness and employee relations point of view, and explaining why it is that it's appropriate to crack on with redundancies, notwithstanding the ongoing furlough scheme. I think most employers will find that they end up having to pay at 100%. And as I say, I suspect that if they don't, they will face claims. And I suspect those claims in due course would be successful for the balance. Now, I think I've said that notice is potentially claimable, or element of notice is potentially claimable under the scheme. I think probably statutory redundancy payments fall on the other side of that line, and it's harder to see that they would be recoverable under the scheme as wage costs. But I dare say some employers will try, and some may receive payment, but I would put a small wager on the fact that in due course HMRC would seek to recoup and recover those. And as I say, I think there's a strong argument for saying that it's outside of the scope and spirit of the scheme for those to be claimed. But clearly some employers may take the view, nothing ventured, nothing gained, may seek to make the application, include it, hope it gets through, and say, well, if in due course, and we know HMRC may come back to an employer for up to 5 years, if in due course the HMRC come back to us and say we've got to repay, well, we'll worry about that later on. But the here and now is so immediate and so pressing that let's try and make the claim under the scheme and see what happens. So I think we'll pause now, and I think Rebecca is going to pick up some of the questions that you've asked so far, and we'll do a Q&A. So over to you, Rebecca.
Yes, absolutely. Thank you, Rustam. And participants, thank you for bearing with us with some of the sound issues I know during that last session. A lot of your questions are asking for clarification of some of the issues in that session. So I'm going to do a quick fire of some of those questions. So can employees be involved in team meetings? Was one of the questions with regards to the contact during furlough that Rustam was talking about. So Rustam, employees in team meetings, presumably this isn't a team meeting that's going to generate revenue or provide any services, perhaps team meeting as a general business update. What's your view? Rustam, you're just on mute still.
Thank you. I think that's fine in team meetings. Clearly, we need to make sure that they're not actually being asked then to do work or to prepare for specific things.
Okay, excellent. And a question around if you haven't furloughed staff, quite an interesting question this, if you haven't furloughed staff, but you then decide to make use of redundancies, could that amount to an unfair dismissal? So I think I'll answer this, but I think the question is really along the lines of, have you done everything possible to mitigate the impacts of or the numbers of redundancies? So in terms of it being an unfair dismissal because you haven't used the furlough scheme, I think that would be quite a stretch. for employment tribunals to say that it was unreasonable not to use the furlough scheme. They may ask, did you consider it, and what were your reasons for not using it? So I do think it should be something as part of your consideration. But you know, it is not compulsory to use the furlough scheme. So it may be that you have to make redundancies for reasons that perhaps are not related to coronavirus, and you couldn't use the scheme anyway. But yes, it's going to be an interesting question, and tribunals, we don't know whether tribunals are going to be more tolerant in 18 months' time when hearings perhaps finally get there as a result of dismissals, redundancies, other issues during furlough, or whether they're going to apply sort of the short memory test and say, well, 18 months on, we're looking at things as to what a reasonable employer should have done in the normal way. But I expect there'll be lots of questions raised at tribunals which were along the line of we had to make quick and quite brutal decisions. But I don't see employment tribunals giving you a great deal of leeway on that. The furlough off question on what's the minimum time before somebody can return after they have been put back into the workplace. So there is no minimum time. So as long as you are furloughed for 3 weeks, if you want to bring somebody back for a week, say, and then furlough them again, then that's absolutely fine. There is no minimum time that they have to be back at work before they can be re-furloughed. A question on annual leave and the carryover. So we had the additional legislation come through about the potential of carryover of 4 weeks additional, the carryover of 4 weeks leave to be taken over the next 2 years if it was not possible to take it during the current period due to coronavirus impact. Now, the question is, do you as a business have to still allow that carryover if you believe it was reasonable for the employee to have taken it? So my view on that is that if you gave the employee opportunity to take their annual leave and they chose not to, then I do think that you can say that 4 weeks should not be carried over. But again, it's one of these areas that has not been tested. It's brand new law. Okay, so a few more questions before we move on to Abby and workforce planning in phase 2 post-furlough. If an organisation wants to commence collective redundancy consultation, or indeed, any redundancy consultation, would the fact that the employee companion is also furloughed mean the consultation should be delayed? So in effect, there's no employee rep available to attend a meeting with an individual who's at risk of redundancy. So Ruston, what's your view on this? So somebody who's got difficulty accessing an employee rep.
I think that's a very good question, and if I'm honest, I hadn't got my head to that one, so whoever's asked that question can't start. I think it's hugely problematic in the same way that being an employee rep in the context of collective consultation, are they working? I think similarly here, there will be that argument and potential issue as to whether or not that person can do that if they're on furlough. And it may be that one has to have a period where they come off furlough, and I appreciate that's going to be very messy, not least from an administrative point of view, but also in the context of claiming on the portal, as I understand it, in terms of trying to claim different rates in different periods. So I think that's going to be one of those practical logistical issues that I think is likely to give some difficulty. I suppose there might be an argument for an employer to agree that a certain number of people would be nominated as the employee representatives individually, who would then be, as it were, a pool or a bank that might be used. But you can see how that might be challenged as well in due course. But I think that might be a sort of half a workaround, but I think it's a real problem.
Yep. Okay, thank you, Ruston. We've had so many questions that have come in, and I don't want to cut Abby short at all. So what I'm going to commit to do is all of the questions that have been submitted, we will provide a Q&A sheet to everybody. anonymised. We won't say who's asked the questions, but we'll provide that Q&A sheet to everybody, because I know there's lots of queries out there. But I'm going to pass over to Abigail now and take you through what is, I think, a really difficult situation for HR at the moment, and for businesses trying to work out what does happen next post-furlough. So Abigail, over to you.
Thanks, Rebecca. I thought it'd be useful, last poll, don't worry, of the day, to see who's actually started planning for post-furlough. So you've got a yes, no, or an unsure answer there. Maybe a bit of furloughitis if for the unsures. Now the furlough fog's sort of lifting a little. I know a lot of employers are starting to consider what measures may be necessary after the furlough period ends, or actually whilst we're still in it now that it's been extended. So we'll just wait for those results to come through. And I should say, while we're waiting for the results to come through, we are running another webinar next week on collective consultations. And within that, mainly because I'm writing the materials so I can see all your questions coming through, I will make sure that we put in things around the practicalities of consulting on an individual and a collective basis, based on your questions coming in today, and give you our thoughts on where we feel like the tribunals may land. So that's just a little advert for next week. We'll just wait for the... so most of you are planning for post-furlough, which is, I think, very sensible, because the furlough period will only last until the end of June, and then there's obviously going to be a big concern as to what is needed within the business going forward. And although a lot of the planning is unfortunately around redundancies, we're getting a lot of organisations who are asking us how they can preserve skills and expertise within the business, because there is such an unknown as to how long the current status is going to go on for, albeit it does look like it's going to go on for quite some time. So along with redundancy considerations, there's a variety of different measures that we're looking at with our clients in order to make cost savings on a temporary or longer term basis, or to realign business with the new challenges that they face or they're anticipating facing. And most of those do attract some legal and commercial implications, such as, obtaining consent, potential collective consultation obligations, and potential impact on morale and public image, which I know Rebecca touched on in the context of furlough at the start of the session. So I'll go through the next few slides just on some certain areas that we've been looking at with clients. And clearly remuneration tends to be fairly high up the list of considerations for cost saving for most organisations, not least because it has the greatest impact on bottom line normally. And a question we get asked a lot is whether and to what extent pay reductions can be imposed. And the starting point is unilateral variation of a term of an employee's contract does give rise to some quite significant risk for claims. But there's a lot of reduction by consent that's going on at the moment, and that's a great way of getting through some cost reduction on a temporary basis, provided that it doesn't take employees below national minimum wage. If there's a compelling and solid business reason for having to make longer term reductions in salary levels, then it's possible to look at dismissal and re-engagement as an ultimate solution if employees don't agree to those changes. And as Rustam mentioned in his section, that would, if there are 20 or more employees within one establishment, that would trigger collective consultation obligations. But that's certainly something that we're also looking at with clients where they feel that the recovery will take a lot longer than has initially been planned. We're also discussing with employers more creative solutions to really implement cost saving and salary reductions by more of a creation of a company furlough arrangement that will commence after the end of the government scheme, which is effectively a temporary change to contractual hours or pay or location, but under the umbrella of more of a company furlough arrangement, where employees are kind of tend to be a little bit more used to certainly the terminology of it, and they may see that as an easier way to understand the continuation of a cost saving measure for the business on a temporary basis. So we're seeing a lot of businesses trying to get a little bit creative with contractual changes like that. Pay reviews are quite commonly and quite typically being deferred. There's very few contracts that give a right to an annual increase in pay. So to the extent there is only a promise of a salary review rather than an increase itself, then that is another area that employers are taking advantage of. Whether an employer can withdraw or cut down on a bonus depends on whether the arrangements are discretionary or contractual. As with all other contractual terms, if the bonus arrangements are contractual and the preconditions have been met, then employee consent would be required for any variation. But many employers are seeking to defer bonuses as an immediate cost-saving measure. And a lot of our clients are also reviewing the benefits that the business provides, using this as a good opportunity to look at whether things are being underutilised but are actually costing the company quite a lot of money, or whether there are different and less costly benefits that could be provided as an additional option if there are a suite of benefits, such as if there's private health medical insurance, whether there's an add-on at a low cost that might give video access to a GP, which is something that a lot of employees would like at this point in time. Moving on and looking at hours and location, I mean, we are in very strange times at the moment. There are almost exclusive home working arrangements in a lot of sectors, and really a new normal, I think, that we're entering into sort of post-COVID, and a different approach, I think, to office-based roles. I've already been speaking to clients who have identified entire teams are functioning just as well at home as they did in the office. And actually, after the restrictions are eased or lifted, they're thinking of offering home-based roles as an alternative to office. And many of you might have heard yesterday the Barclays chief executive saying that he thought the days of large office blocks were over. And I think as the restrictions are starting to ease, the post-lockdown integration is going to be a challenge for many employers. There'll be the reluctant returners, those who might be actually quite nervous about commuting into the office, but also some who are probably beating down a path to get to the office after a period at home with their family. And that's going to need some careful working through from a practical perspective, but also from a legal perspective, if the reluctance to return is because some sort of health and safety concern. And I think going forward, we're certainly discussing as a team whether it would be harder to refuse flexible working requests in the future, where employees have demonstrated quite successfully during lockdown that their roles can be performed quite well at home. So certainly going forward, we believe that greater scrutiny is probably going to be given as to why and for what ultimate purpose refusals are necessary if the request is for some or all of a working week to be performed remotely. And clearly with a different attitude to flexible working, this could create cost reductions in terms of office space, IT and general infrastructure costs. Obviously that depends on where you are, say, in your commercial lease. But if you're coming up to the end of it, I know a lot of organisations are looking at whether they need the same scale of office, whether they can be a bit more creative with their office space and therefore their rental costs going forward. And changes don't have to be permanent. A lot of employers that we're talking to actually think the optimal build-up would be reduced working hours at the end of furlough, or as the lockdown is eased, with hours building up as work increases. Now, in the past, that might have been quite a difficult sell to employees, but with things like schools, potentially staying closed until September, there may be pockets of your employee group that would be quite prepared to agree to hours cuts on a temporary basis and a build-up to fit in with their care and responsibilities or their home life going forward. Now, moving on, we have also been a lot of employers, and I don't know if you're like if your organisations like this, has a particularly busy departments, but other departments who are have had a significant downturn in work. And it is possible to move employees. I mean, the starting point would be if there's no need for a headcount reduction, but with just a temporary change. Sometimes contracts, if it's not a significant change, will allow mobility or redeployment. In the absence of any suitable contractual provision, or if there's a more significant change, consent would be required. And clearly that's probably going to be easier if it's a smaller department and the change is relatively minor. If it's a large-scale redeployment exercise, that may trigger a collective consultation with affected employees if there are going to be significant changes in those contractual terms and their duties. And if the redeployment is considered because otherwise that quieter department really would be at risk of redundancy, then we would suggest that a redundancy process is probably the most sensible first step, because you are then able to identify the correct pool for redundancies, decide on selection criteria and potential alternative jobs, of which the busier department would be one. And then finally, I just wanted to talk about some of the other areas that employees are looking at. So just moving on a slide. Recruitment freezes, I think most employers are doing. And that is generally a very easy option with very few employment law implications. One warning I would just give is if you are in a redundancy process and need to recruit for an exceptional role, you would just need to be aware of the need to potentially open that out to people who are at risk, or if you're in a collective consultation, inform the collective, the employee reps, of the need to recruit that exceptional role and why it's believed that it can't be filled internally. And training budgets, I think, are being reduced or frozen quite typically across the board. So it's really important to try and maximise the benefits of any budget that you do have moving forward. So a lot of our clients are undertaking a review of what they have in place and the return on investment by talking to managers and really asking what makes sense for them in a remote workforce. What do they value and what makes the biggest difference? Online platforms are becoming increasingly more sophisticated and can provide a lower cost solution to physical training sessions. So can add real benefit on a relatively limited budget. And of course that can be extended to your employees on furlough too, provided that there's no revenue generation for the business. So I'm going to hand back to Rebecca to recap on some of the issues and to look at some of your questions.
Thank you, Abby. That's great. I mean, I think one thing that we do know is that we are all going to be phenomenally busy in the next few months with, furloughing and with the post-workforce planning, and that is going to, continue during 2020. So good luck, everybody. Some good practice recommendations. Review your furlough arrangements and the agreement. I know the stats, the poll results said that a number of you were likely to do that, but have a look, are they fit for purpose? Second employment, be ready with your answers on that. Determine your annual leave approach. So Rustam provided some information on the annual leave. What I would also say is that have a look on our DMH website. We've got a coronavirus hub, and we've got an employment section with lots of information, and we've got an annual leave blog with some more information on the treatment of annual leave. Although you might be a little bit worried about maintaining communications with employees, please do so. You probably can't communicate too much, even for those, sort of employees on furlough. They'll be sitting at home, they'll be wondering what's happening. So do make sure you maintain communications on future plans. And as Abby went through the post-furloughing options and considerations, it really is time that, now is the time for planning for that, because the 30th of June is going to be on us incredibly quickly. So we've had so many questions. I'm just going to take a couple now, because I know some of you will be moving on to 11 a.m. meetings, etc. But just time for a couple of questions. And as I said, we will come back to everybody with a full answered list of all of those questions that you both pre-submitted and that you've submitted during the last hour. One question: if furloughed staff are doing work that doesn't create revenue, e.g. building training modules, is this possible? I'd say absolutely no, because if they're building training modules, that will be providing services for the business. Now, I don't know if this is a training company, but even probably building training modules for internal employees, it's still providing services. So don't risk your wage cost claim by asking somebody to do that. Lots of questions on what holiday pay should be made, so what rate should it be? I think most of us are now sort of at the view that holiday pay for the first 5.6 weeks needs to be paid at what is the normal remuneration. So that effectively means you're going to have to pay 100%, even though somebody is on furlough, in respect of any holiday pay. So you can't get away with just paying the 80% that you receive from the government, or even 80% if you're topping up of actual salary. It needs to be 100%. Anything over that 5.6 weeks, that's your contractual holiday pay. And if you agree with the employee that that should be paid at 80%, then that's okay. But you will have to agree with the employee that is how it should be paid, because you can't contract out of people's statutory employment rights. And that's what you would be doing, even if you got agreement from people to go and pay 80% for the first 5.6 weeks. But lots and lots of questions on annual leave have been coming up. So I am going to end here. There's clearly a need for these sessions with the numbers of you on the call, the numbers of questions. As Abby's already mentioned, we have a collective redundancy webinar on the 7th of May. And please don't forget, collective redundancies, it's not just relevant for those people that you're going to be terminating on what I would call a traditional redundancy basis, but if you're looking at changing terms and conditions and there are 20 or more employees in your organisation that's going to impact, collective redundancy consultation potentially comes in to the situation as well. So please do remember that. But thank you very much for joining us this morning, and we really hope that you'll join us again over the next 3 weeks when we run the next sessions. But thank you and have a great day. Thank you. Bye-bye.